Superior Court of the State of California, County of Monterey, Department 16, now in session. Honorable Judge O'Farrell presiding. Please be seated and come to order.
Thank you very much and welcome. Some familiar faces, familiar teams. It seems like every second year or so we have Carmel and Pacific Grove here. First of all, congratulations on your accomplishment to get to this final round of the moot court or mock trial competition. It's not an easy accomplishment to have done that against a lot of talent that's out there in the other schools. The only advice I give, and you probably don't need it now because you've heard it from so many other judges in the preliminary rounds, is just try to relax a bit as much as you can and just be yourself. Being yourself really brings out the best in you. So with that, let's get started, and I'll ask if both sides are ready. Ready for the people?
The people are ready, Your Honor.
Thank you. Ready for the defense?
Yes, Your Honor.
Thank
May
you.
we proceed with introductions first?
Yes.
I am proud to introduce the 2015 Pacific Grove Mock Trial Defense Team. Good afternoon, Your Honor, scoring attorneys. My name is Delphi Myron, and I will be giving today's defense pretrial motion.
Good afternoon, Your Honor, scoring attorneys. Noah Thanos, counsel for Evan Shem.
Good afternoon, Your Honor, scoring attorneys. Wesley Harden, counsel for Evan Shem.
Good afternoon, Your Honor, scoring attorneys. Olivia Jameson, counsel for Evan Shem.
Good afternoon, Your Honor, scoring attorney. My name is Brooke Fairgarden, and I am Jamie Cardania.
Good afternoon, Your Honor, scoring attorneys. My name is Sarah Bitter, and I am Evan Shem.
Good afternoon, Your Honor, scoring attorneys. My name is Douglas Dow, and I am Sydney Ogden.
Good afternoon, Your Honor, scoring attorneys. My name is Michael McMurtry, and I am T.M. Little.
Thank you.
Good afternoon, Your Honor, scoring attorneys. My name is Yassine Al-Shakli, and I am your bailiff. At this time, may I shadow clerk please introduce yourself?
Yes, please.
Good afternoon, Your Honor, scoring attorneys. My name is Nicole Weber, and I will be the shadow clerk for this trial. May our coaches please introduce themselves?
Yes.
Good afternoon, Your Honor, scoring attorneys. Diana Rosenthal, attorney coach.
Good afternoon, Your Honor, scoring attorneys. Elaine McLeaf, attorney coach. Good afternoon, Your Honor, scoring attorneys. Joy McMurtry, attorney coach.
Good afternoon, Your Honor, scoring attorneys. Emily Hickok, attorney coach.
Thank you, and good afternoon to all of you. And the prosecution, would you like to introduce your team?
Yes, Your Honor. Good afternoon. My name is Anna Gumberg, for the people.
Good afternoon, Your Honor. My name is Erica DePilatis, lead counsel for the people.
Good afternoon, Your Honor. My name is Gina Sakota, counsel for the people.
Good afternoon, Your Honor. My name is Ren Tao, counsel for the people.
Good afternoon, Your Honor. I am Detective Reese Barron.
Good afternoon, Your Honor. I'm Professor Marty McCullough.
Good afternoon, Your Honor. I'm Charlie Gibbons. Good afternoon, Your Honor. I'm Bernie Worcester.
Good afternoon, Your Honor. My name is Casey Redfield, and I am the clerk. Today, I will be giving visual time signals, 2 minutes, 1 minute, 30 seconds, and a visual and verbal stop.
At this time, Your Honor, I'd also like to introduce our coaches, Mr. Stryer, Ms. Stivers, and Mr. Liner.
Thank you very much. The case is People versus Evan Shem, and it's charging 1 count of grand larceny against Mr. Shem. Mr. Shem has entered a plea of not guilty. That's the issue before the court today. And I understand the defense would like to make a pretrial motion. Is that correct, to exclude certain evidence?
Yes, Your Honor.
All right, please go ahead.
Thank you. May I proceed?
Please.
On July 7, 2014, Detective Barron violated my client's Fourth Amendment rights when she conducted a warrantless and unreasonable search of Evan Shem's storage unit. Detective Barron came to Evan Shem's residence looking for evidence related to an art theft. She then asked my client for permission to search the apartment. Shem consented. It was after this initial search of the apartment that Detective Barron moved outside to search a locked storage unit without consent. Your Honor, this search was unconstitutional. Detective Barron failed to ask Evan Shem for consent to search the storage unit, and instead asked Shem's ex-roommate, Charlie Gibbons, someone with no access or control over the storage unit, for consent to a search. Detective Barron was not acting in good faith. The evidence found in that storage unit should be suppressed for the following reasons. 1. Evan Shem only consented to a search of the apartment. No reasonable person would have assumed that the detective's request to search the apartment also included a locked storage unit outside. Had the storage unit in our case been an unlocked room within the four walls of the apartment, for example, a bathroom, as with the case of U.S. v. Pena, it would have been objectively reasonable for the detective to conduct a search. However, this was not the case, not our case. 2. Evan Shem alone held the right to consent to a search of the storage unit. At the time of the search, Charlie Gibbons, a friend of Evan Shem's, was in the process of moving out of the apartment, making her a temporary guest at most. In the case of People v. Cruz, the court ruled that transient guests can consent to searches of their belongings and only their belongings. Now,
Let me go back to the consent just for a moment, if I could. When the officer asked consent to search, there was kind of a go-ahead type of a approval given. And let's assume, instead of it being the carport, that I'm not clear whether that was actually contiguous to the apartment or perhaps separated by a small amount, but supposing it was just a home, a house, a typical residential home, and it had it included a garage as part of the house. I mean, wouldn't it be reasonable to think if someone said, yeah, go ahead and look around, that would include the garage?
perhaps, Your Honor, seeing as a garage is part of the same accommodation as the home, unlike the storage unit, which was also locked. And we know from People v. Murillo that items or places that are locked indicate a further necessity of privacy, meaning that the officer would probably have to ask for consent to search a locked garage.
Okay, so the locking aspect of this is an important element, right?
In addition, the detective had no objective, reasonable basis to believe that a storage unit located outside of the apartment fell in her request of saying, "May I search the apartment?"
Thank you.
Thank you.
Please.
In the case of People v. Cruz, the court ruled that transient guests can consent to their belongings and only their belongings. Now, it's important to remember that when asked about the storage unit, Charlie Gibbons told Detective Barron that it belonged to Evan Shem, implying that Evan Shem was the sole owner of the storage unit, meaning that Detective Barron would have had to ask Evan Shem for consent to a search, because Charlie Gibbons had no access or control over the storage unit, and the detective had no evidence to suggest otherwise. Which brings me to my third point. Detective Barron was not acting in good faith. In the case of People v. Murillo, the court ruled that because officers failed to receive consent from the owner of a locked suitcase, their search of that suitcase was unconstitutional. Now, Your Honor, this case is analogous to ours in that Detective Barron failed to receive consent from Evan Shem for a search of the storage unit, and instead asked Charlie Gibbons. But what Detective Barron didn't ask Charlie Gibbons, the simple four-worded question, and the reason why we're here today, do you live here? And because Detective Barron failed to determine whether or not Charlie Gibbons was in fact a resident or even held the right to consent to a search of the storage unit, she cannot claim good faith. The evidence collected in that storage unit should be suppressed, and the defense respectfully asks that you grant our motion. Thank you.
Thank you. The prosecution?
Yes, Your Honor. May it please the court?
Yes, please, go ahead.
Your Honor, the people ask that you deny the defense's motion to suppress the evidence obtained in Detective Barron's search of the defendant's storage cabinet on July 7th. Detective Barron went to the defendant's apartment and asked her if she could search it, and the defendant said, "Sure, take a look around," and waved her hand. Detective Barron went on to search the apartment, and then, to make sure she didn't miss anything, included in the initial search, she went outside and found the adjacent carport and storage cabinet marked letter B, corresponding to the defendant's apartment B. Detective Barron then saw Miss Gibbons getting out of her car in the parking space, and she asked Miss Gibbons if the storage cabinet belonged to the apartment, and Miss Gibbons said the storage cabinet belonged to the apartment. Detective Barron then asked if she could search the storage cabinet, and Miss Gibbons gave her directions to the key, which was hanging unobstructed from view on the defendant's kitchen wall. Detective Barron went on to take the key, search the storage cabinet, and seize what is marked in today's trial as Exhibit D.
The defense brought up the point about Shem being right there, apparently in the house, and that the officer wasn't acting in good faith when he asked, or she asked Gibbons for consent. Do you think that was reasonable, or do you think, since it was really the consent originally came from Shem, that he should have inquired of Shem whether he had consent to search that storage cabinet or not?
Well, Your Honor, because the storage cabinet was indeed part of the same accommodations as the apartment, Detective Barron already believed that she had consent from the defendant. She only went on to ask Gibbons again because she wanted to ensure the legality of her search of the storage cabinet, and at that time she believed that Ms. Gibbons was in fact a co-occupant of the apartment.
Okay, thank you.
Your Honor, Detective Barron's search of the defendant's storage cabinet was constitutional. The defendant herself consented to the search of the storage cabinet when she consented to the search of her apartment. Today's case is like U.S. v. Pena, where the defendant consented to the search of his hotel room, and when the police found drugs in the bathroom, he claimed that he had only consented to the search of the hotel room and not the bathroom, and therefore the drugs should not be permitted into trial. But the court held that it was reasonable for the police to believe that the bathroom was included in the scope of consent, as it was part of the same accommodation as the hotel room. And Your Honor, the storage cabinet is part of the same accommodation as the defendant's apartment. They were rented together, they were marked correspondingly, and furthermore, because of the key's obvious location in the apartment, and because the only way to get to the storage cabinet would be to go through the apartment and take the key off the wall, it is, in fact, part of the same accommodation. But even if the court finds that the defendant's scope of consent did not extend to the storage cabinet, Ms. Gibbons consented to the search. And pursuant to U.S. v. Matlock, co-occupants can consent to the search of shared grounds. And when Detective Barron asked Ms. Gibbons if she could search the cabinet, she gave her directions to the key. And why else did Ms. Gibbons give these directions if not consenting? Now, Your Honor, on July 7th, Ms. Gibbons was in the process of moving out of the defendant's apartment. And there's no case precedent to support the idea that one's name has to actually be on the lease to give them access and control. But whether or not Ms. Gibbons really did have that access and control doesn't matter in today's case. Because what matters is that Detective Barron had a good faith basis in believing that she did. Detective Barron saw Ms. Gibbons at the defendant's apartment twice in 2 days. And on July 6th, she saw Ms. Gibbons coming out of the apartment. Ms. Gibbons had a key to the apartment. Ms. Gibbons had belongings in the apartment, and on that day when Detective Barron asked Ms. Gibbons if she could search the apartment, Ms. Gibbons, instead of saying she didn't live there, declined Detective Barron's consent, implying not only occupancy, Your Honor, but also control. And then Detective Barron saw her there again the next day, only furthering the implication that she lived there. Your Honor, because the defendant herself consented to the search of the storage cabinet, because Ms. Gibbons consented to the search of the storage cabinet, and because Detective Barron had an overwhelming good faith basis in believing that Ms. Gibbons could consent, we ask that you deny the defense's motion to suppress Exhibit D and all related testimony. Thank you, Your Honor.
Thank you. Any rebuttal from the defense?
Yes, Your Honor. Prosecution has made a lot of claims about the detective's diligence in this search, but Detective Barron did miss something. She missed the storage unit upon first asking Evan Shem for consent to a search of the apartment. Detective Barron claims that she didn't even know it existed at the time. Now, that's because no reasonable person would have assumed that Detective Barron's request to search the apartment also included the storage unit, which was located outside, unlike in the case of U.S. v. Pena, in which a bathroom was part of the same accommodation of the hotel room.
Don't you get into some pretty fine points, though, when you're talking about what is the same accommodation? In other words, like we discussed earlier about a attached garage. You can think of so many other options, a cabana or something by a pool, perhaps, that has some cabinets by it. It all seems to be part of one's living environment. Doesn't it put an unduly difficult decision upon the officer to have to seek consent for each one of these particular entities or parts of the living environment? Does that seem reasonable?
Well, exactly, Your Honor. What's reasonable should be legal. So the officer should have asked Evan Shem and should have assumed that Evan Shem understood that when she was consenting to a search of her apartment, she meant everything within the four walls. Now, something outside that's locked doesn't really pass that objective reasonability test. As a cabana may differ in that regard, we don't know what would be reasonable in the hypothetical that you've given me. However, a storage unit locked outside is not part of an apartment.
Thank you.
Furthermore, Charlie Gibbons was not a co-occupant. And even if she had been, her actions were not unlike those of a friend staying over. Why did she decline the officer's request to search the apartment on Detective Barron's first visit to the apartment? Because she knew it belonged to Evan Shen. For all of these reasons, the defense respectfully asks that you, to bring up the case of Illinois v. Rodriguez, in which Gail Fisher lied to the police, stating that our apartment and using a key to open the door to the apartment convinced the police that Gail Fisher was in fact a co-occupant. Now, the test to decide whether someone really is a co-occupant relies heavily on visual and verbal affirmation. Charlie Gibbons provided neither to Detective Barron, and the responsibility fell upon Detective Barron to determine whether or not Charlie Gibbons actually had the right to consent to a search of the storage unit. Evan Shen was just sitting a few feet away at the time. Detective Barron could have easily asked Evan Shen, the person she knew to be the owner of the storage unit, for consent to a search. And for all of these reasons, defense respectfully asks that you grant the motion.
Thank you. Prosecution have somebody level?
Yes, Your Honor. Now, defense counsel brought up that because Detective Barron wasn't aware of the storage cabinet when she asked consent of the defendant, that it wasn't included in the scope of consent. But Your Honor, with that would be like saying that a back room that isn't visible from the front door isn't included in the scope of consent because the detective had no knowledge of the defendant's apartment's layout. She didn't know of a back room and she didn't know of a storage cabinet. And Your Honor, because the defendant's key to the storage cabinet was just hanging on the wall in her kitchen, and she knew that a detective was searching her apartment, she should have explicitly objected, telling the detective that the key and the storage cabinet were off limits.
Focusing just a moment on the alleged consent given by Shem, does the fact that the cabinet was locked, does that have any particular bearing on his consent?
No, Your Honor.
The extent of his consent is what I mean.
No, Your Honor, because the key to the storage cabinet and the lock on the storage cabinet is just a formality to keep people who weren't already in the apartment from accessing the storage cabinet. Because once you were in the apartment, you had access to the key that would open the storage cabinet. But someone from the outside wouldn't have that key. For the defendant was implying in this that she was merely trying to keep people who weren't already in her apartment from going into the storage cabinet. But once people were in the apartment, they had access to the storage cabinet. And that was the only way you could get to the storage cabinet.
Thank you.
Now, Your Honor, defense counsel also brought up that because Ms. Gibbons was a transient guest, she couldn't consent. However, Ms. Gibbons stayed at the defendant's apartment for 5 months. She had a key to the apartment, she had belongings stored in the apartment, and furthermore, Your Honor, it didn't matter whether or not Ms. Gibbons really was a transient guest or a permanent guest. because what matters is what Detective Barron saw. And Your Honor, the only 2 times Detective Barron went to the defendant's apartment, Charlie Gibbons was there. Charlie Gibbons was going in and out of the apartment. Charlie Gibbons knew of the layout of the apartment and knew how to get into the storage cabinet, and she had a key to the apartment and belongings stored in the apartment. And it was absolutely reasonable for Detective Barron to believe that she lived there. So because the defendant herself consented to the search of the storage cabinet, and because Ms. Gibbons consented to the search of the storage cabinet, and because Detective Barron had a good faith basis in believing that Ms. Gibbons could consent, we ask that you deny the defense's motion to suppress the evidence obtained in Detective Barron's search of the defendant's storage cabinet. Thank you.
Thank you. It's a close case and argued well. I think there's 2 elements to it. There's the alleged purported consent by Shem, and then there's the, if that doesn't pass muster, there's the alleged consent by Gibbons, Mr. or Ms. Gibbons. The officer asked for consent to look around, as I understand it, and that was what Shem said, just a sweeping motion. Go ahead, look around. I think it's reasonably implied from that he can look around, or she can look around to areas that would be part of that living environment, whether it's a garage or whether it's a carport, as in this case, or a cabana for that matter, unless he's restricted in some way by the consent. And the consent wasn't restricted. In fact, it had the connotation of being kind of open. So I think his consent was valid, and the officer did act reasonably. In addition, the fact that it was locked, I don't think really adds much to it, because in an open carport, one locks it not to keep the police out or anything like that. It's locked to keep anyone out from stealing your bicycle and so on. If for some reason that wasn't the case, I think what Mr. Gibbons said was adequate to give him consent to go ahead and search. The officer had reason to believe, as brought out by the arguments, that Mr. Gibbons was a co-occupant there. He asserted enough authority to refuse consent just a couple of days earlier, and he didn't say, I don't have the authority, I don't really live here, therefore I can't give you authority. He just said, no, I'm declining to give you the consent. So he did assert authority, and the officer did seem to have a reasonable basis for believing he was a co-occupant. And so I believe his response by simply pointing to the key and saying, whatever he said, there's the key, was satisfactory, and the officer was reasonable in assuming he had the right to do that. So I will deny the request to exclude the evidence. Okay.
Permission to rearrange for trial, Your Honor?
Absolutely.
Thank you.
Where's the bailiff? Can I have the bailiff for just a moment, please? Are we ready?
Yes, Your Honor. Before we begin, the people have some preliminary matters we'd like to address.
Yes, go ahead, please.
First of all, Your Honor, we'd like to inquire as to whether or not you have all the legal documents in this case, including the most recent errata dated July 5th, 2015. Excuse me, January 5th, 2015.
I would have said yes, except when you put a date to it, it makes me suspect maybe I don't. January, what was the errata on that date?
January 5th, 2015.
Right. What is it, though, that's
The
correct?
content of the errata, there was a change to errata number 7. To page 22, line 2, after yes, it says I continued to ask. It's more of a grammatical error than a...
Oh, all right. We can live with that.
Yes. Also, Your Honor, the people request that exhibits A, B, C, and D be marked for identification.
Yes, so marked.
And finally, Your Honor, we'd like to ask permission to approach the exhibits during opening and closing statements.
Yes.
Nothing further from the people, Your Honor.
All right. The defense have any preliminary
No
Topics?
objections, Your Honor, and the defense will also ask to be able to approach the exhibits during opening and closing as well.
Yes, granted.
Thank you.
All right, the people are going to make an opening statement.
Yes, Your Honor.
Please go ahead.
May I please?
Yes. mhm.
Last July 4th, Professor Marty McCullough hosted her annual Independence Day party. It was a lavish affair with hundreds of guests touring her private art gallery, sipping champagne and eating hors d'oeuvres, and when night fell, going outside and watching a magnificent fireworks show. Not a single person there knew that they were on the scene of an art gallery. Earlier that evening, the defendant came to that party wearing a backpack. Hidden inside was a fake painting, a copy of a painting called Treason, which the defendant planned to steal. Later that evening, after the defendant had cleared everyone out of the gallery, the defendant took the fake out of her backpack, swapped it with the real one on the wall, and walked away. This is the painting the defendant stole. This is the fake she left behind. There are 3 people in this courtroom who can tell the difference: the painting's owner, the people's expert, and the defendant. To the untrained eye, these paintings are indistinguishable. So how will we prove that this is the real painting? Well, not only will we present convincing expert testimony proving that this is the authentic Treason, but we will also offer the incriminating words and actions of the defendant herself to prove beyond a reasonable doubt that the defendant stole Treason. At the close of today's case, we will ask that you find the defendant guilty of grand larceny. Thank you.
Thank you. Defense wish to make an opening statement at this time or reserve it?
The defense would like to give their statement now, Your Honor. In the world of art, beauty is in the eye of the beholder. Depth and meaning are qualities fabricated by the perception of the viewer. Qualities subject to an individual's own ignorance and bias. Like art, this case is a matter of perception. Today, Your Honor, the defense will present the fault in the perceptions of Evan Shem's accusers, and will make clear the undeniable reasonable doubt presented by what our witnesses have to say. Your Honor, the defense will provide 2 reasonable interpretations of the evidence, and have you asking 2 simple, glaring, unanswered questions at the end of today's trial. First, whether or not a crime occurred. Today, you will hear from art authentication expert Jamie Sardegna, who will tell you that the treason hanging on the wall of the McCullough Gallery is Yazoo's authentic painting. You will also hear from the defendant herself, who will tell you that she was a loyal and honest art student and intern to Marty McCullough, and that she would never attempt to steal treason. She will tell you that on the night of July 4th, she carried out her duties as a docent responsibly. And second, Your Honor, if a crime did occur, there remains the question of whether or not Evan Shem is guilty. Today, you will hear from Mr. Sidney Ogden, who will tell you that Evan Shem is an honest human being. Moreover, Mr. Ogden will draw your attention to the questionable actions of another guest at the party that night. That person is Charlie Gibbons. And finally, Your Honor, to draw even further reasonable doubt to this case, you will hear from Mr. T.M. Little, who will testify to Evan Shem's hard-working nature on several occasions, including the 4th of July party. Further, Mr. Little's testimony will draw questions as to the soundness of Charlie Gibbons' perception. Your Honor, art and beauty may be subjective, but the truth should not be. At the end of today's trial, there will be 2 reasonable interpretations of the evidence and 1 verdict. Not guilty. Thank you.
Thank you. All right, are the people ready to call their first witness?
Yes, Your Honor. The people call Detective Reese Barron to the stand.
Calling Reese Barron to the stand. Please raise your hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully inform the facts and rules of the mock trial competition?
Yes, sir, I do.
Please be seated. Please state your first and last name, spelling your last.
My name is Reese Barron. B-A-R-R-O-N.
Good afternoon, Detective Barron.
Good afternoon.
What do you do for a living?
I'm a detective with the Hamiltonian Police Department. I specialize in art crimes.
What's your involvement with today's case?
I investigated the reported theft of a painting on July 5th, 2014 at the McCullough Mansion.
What painting was reported stolen?
It was titled Treason by Fletcher Yazoo.
Do you know who reported the theft?
Yes, ma'am. The painting's owner, Professor Marty McCullough, reported it.
Detective, how did your investigation begin?
I arrived at the professor's estate and I searched the gallery.
What did you find in the gallery?
It was very unusual, actually. Instead of there just being a blank space on the wall, there was a painting where treason usually hangs. This is not very common in art crimes.
Why not?
Well, usually thieves don't go to all the trouble to make a copy. It means that whoever stole treason either had the access to someone who could make them a copy or had the ability to do it themselves.
Now, Detective, you said you investigated the gallery. Did you find any signs of a forced entry?
No, ma'am. I searched the entire perimeter. I found no break-in points or any signs of a forced entry. I concluded that this was an inside job.
What's an inside job?
It means that whoever stole treason had access to that gallery, so they didn't have to break in.
Detective, during the course of your investigation, did you ever determine who had that kind of access to the gallery?
Yes, ma'am. Evan Shem did.
Do you see Miss Shem in court today?
Yes, ma'am, I do. She's sitting at the end of counsel's table wearing a black top.
Yes, correctly indicating the defendant.
Detective, did you take any steps to interview the defendant?
Yes, ma'am, I did. On July 7th, I went to the defendant's apartment.
And did you search that apartment?
Yes, ma'am, I did.
What did you find?
I found a painting that looked exactly like the one I'd seen at Professor Marty McCullough's mansion just a few days earlier.
Now, Detective, I'd like to turn your attention to Exhibit A. Do you recognize it?
Yes, ma'am. That's a photograph I took of the painting that I found inside Evan Shem's apartment.
And does it fairly and accurately represent the painting at the time you seized it?
Yes, ma'am, it does.
Your Honor, we move the admission of Exhibit A into evidence.
Is any objection?
No objections, Your Honor, other than the understanding that this exhibit is larger than the actual treason, which measures 11 by 14 inches.
That's understood.
Thank you.
Yes, it's received.
Now, I'd also like to turn your attention to Exhibit B. Do you recognize this?
Yes, ma'am. That's a photograph I took of the painting that I found inside Professor Marty McCullough's art gallery.
Does it fairly and accurately represent that painting at the time you seized it?
Yes, ma'am, it does.
Your Honor, we move the admission of Exhibit B into evidence.
Once again, any objection?
Once again, Your Honor, the same understanding about magnification.
And it is received.
Thank you.
Detective, did you find anything else during your search of the apartment?
Yes, I did. I found a note inside the defendant's storage cabinet. At the top of it, the word treason was written. And underneath that, there were several names.
During your investigation, did you ever discover the significance of those names?
Yes, ma'am. My department investigated it, and we figured out that those were the names of local art dealers who owned other works by Fletcher Yazoo.
Now, turning your attention to Exhibit D, is this a photograph of the note you seized?
Yes, ma'am. I took that photograph.
And does it fairly and accurately represent the note at the time you seized it?
Yes, ma'am, it does.
Your Honor, we move the admission of Exhibit D into evidence.
Once again, any objection?
No objections from the defense, Your Honor.
Now, Detective, earlier you mentioned that you seized a painting from the defendant's apartment. What did you do with that painting?
I took it back to the station with me, and then I gave it to Bernice Worcester to examine it.
And after Miss Worcester examined that painting, what did you do?
I arrested Evan Shem for the theft of treason.
Thank you, Detective. Nothing further at this time, Your Honor.
Is some cross-examination?
Yes, Your Honor. Ms. Barron, you conducted an investigation at the residence of Marty McCullough, correct?
Yes, sir, I did.
On July 5th?
Yes, sir.
In response to a call about a stolen artwork, correct?
Yes, that's correct.
Upon arrival, McCullough told you that her painting Treason had been replaced with Faith, correct?
Yes, she did tell me that.
On July 5th, you entered the McCullough gallery, correct?
Yes, I did.
Upon first entry, you found no immediate signs of theft, correct?
Yes, I found no immediate signs.
You found no break-in points?
No.
No signs of illegal entry?
No, there were no break-in points or signs of a forced entry.
No blank, empty spaces on the walls?
No, it had been replaced.
Blank. Objection, Your Honor. This witness is speculating as to the authenticity of the paintings.
I didn't catch that. You want to address it?
Yes, Your Honor. Detective Barron said that it had been replaced. And this is not speculation, as it's something she perceived with her five senses.
Would you ask that question again? Because there was kind of an interruption between both of you, and I didn't quite get the answer. You may be right, but I have to hear it.
Yes, Your Honor. You found no blank, empty spaces on the wall?
No, it had been replaced.
And your objection is speculation. Yes, I'll sustain the objection.
Thank you, Your Honor. Ms. Barron, blank, empty spaces, which are the hallmark of cases concerning art theft, correct?
Yes, typically, artists don't bother to make a copy.
Nevertheless, you found no fingerprints pointing to my client?
Yes, there were no identifiable fingerprints.
No fingerprints pointing to anyone, Ms. Barron?
Yes, the fingerprints I found were not identifiable.
On July 4th, Marty McCullough held a party, correct?
Yes, she did.
And on July 5th, you reviewed the guest list of this party with her, correct?
Yes, my department and I investigated it thoroughly.
And Marty McCullough pointed out the name of Evan Shem on that list, correct?
Yes, Evan Shem was her intern.
Ms. Barron, by this point in the investigation, you base your opinion of my client as a person of interest solely upon what you learned from Marty McCullough.
I took this investigation very seriously, and I investigated it
Ms. Barron,
very seriously
that's
as
not
well.
my question. My question was that at this point in the investigation, you based your opinion of my client as a person of interest solely upon what you learned from Marty McCullough.
Yes, given the fact there was no physical evidence, I had to investigate like this.
Thank you. And you say that your department reviewed the rest of the names on the guest list, correct?
Yes, sir, that's correct.
And found no leads?
Yes, they found no leads.
Ms. Barron, Evan Shem was on this guest list, correct?
Yes.
Evan Shem had been invited to the party by Marty McCullough, correct?
Yes.
Charlie Gibbons had not been invited to the party by Marty McCullough, correct?
Yes, Charlie Gibbons had not been invited by Miss McCullough.
Charlie Gibbons had been invited by Evan Shem, correct?
I believe that's correct, yes.
As a +1?
Yes.
Charlie Gibbons was not on the list of people invited to the party by Marty McCullough, correct?
No, she was not.
Thank you. And on July 6th, you visited the apartment of my client, correct?
Yes, sir, that's correct.
There, you approached an individual who self-identified as Charlie Gibbons, correct?
Yes, sir, that's correct.
Miss Barron, the only questions you asked Charlie Gibbons were questions about Evan Shem, correct?
Yes, I wanted to know if Evan actually lived there.
On July 7th, with the permission of Evan Shem, you searched her apartment, correct?
Yes, sir, I did.
There, you found a canvas resembling treason, correct?
Yes.
However, Miss Shem readily admitted to creating that canvas, correct?
Objection, Your Honor, hearsay.
Your response?
Your Honor, this instead goes to the bias of the investigation. This is not being offered for the truth of the matter, but as to the bias of the investigation, and to show that finding a replica in Ms. Shem's apartment was not out of the ordinary.
Well, it wouldn't be hearsay if it doesn't go to the truth of the matter asserted, but I can't see where it would not be going to the truth of the matter asserted under these circumstances. I'll sustain the objection.
Yes, Your Honor. Move to strike if any answer given.
Motion granted.
Thank you, Your Honor. Ms. Barron, this was not the only replica in the apartment, correct?
Yes, there were several other replicas that the defendant had made.
And this replica was not hidden in the apartment, correct?
It was rolled up in the closet.
Ms. Barron, this replica was in plain view.
Yes, it was.
Thank you. No further questions, Your Honor.
The prosecution have some redirect?
No redirect, Your Honor. May Detective Barron be excused?
Yes, thank you. You're excused. And the next people's witness, please.
Yes, Your Honor. The people called Marty McCullough to the stand.
Calling Marty McCullough to the stand. Please call me. Please raise your right hand. Please solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition.
Yes, I do.
Please be seated. Please state your first and last name, spelling your last.
My name is Marty McCullough, M-C-C-U-L-L-O-C-H.
Good afternoon, Professor McCullough.
Good afternoon.
What do you do for a living?
I'm a professor of art history at Hamiltonia University.
Professor, why are you here today?
I'm here because my favorite painting, Treason, was stolen from me.
Objection, Your Honor, speculation.
Would you like to address that?
Your Honor, I'd like to ask as to what is being speculated by Professor McCullough.
Apparently the fact that it was stolen as opposed to lost, perhaps, I suppose. Is that the objection?
Yes. Or excuse me, opposed to the fact that the painting never left the wall.
All right. Okay. And any other response you'd like to have?
Well, Your Honor, if I may make an offer of proof, Professor McCullough will testify that she has had treason in her possession for over 30 years. By looking at the painting on the wall, she could tell that it was a different painting.
I think your point's well taken. I'll allow it. Overruled.
Thank you, Your Honor.
Okay.
Could you tell us a little bit about the painting that was stolen?
Of course. It's called Treason, and it was painted by Fletcher Yazoo. I inherited it from my father after he passed away. I'm really quite fond of it.
Where did you keep Treason?
Well, since art was such a huge part of my life, naturally I have a huge art collection. I kept my most precious pieces in an art gallery, and that's where Treason was.
Was there any sort of security on this gallery?
Yes. It's climate controlled and there's no windows. There's one door and it had an alarm. The only way to gain access without activating the alarm was by using a code on a keypad.
Besides you, who had knowledge of the security system?
Well, the only other person I trusted with that code was my intern, Evan Shem. I gave her the code as part of her internship.
In fact, on July 4th, she was...
I can ask another question,
Please
Your
do,
Honor.
yes. Sustained, yes.
Thank you, Your Honor. Did you give Ms. Shem access on any particular day?
Yes, on July 4th, she was supposed to be the last one out of the gallery and to lock the door behind her.
Now, Professor, when did you first discover that treason was missing?
It was the morning after the party, and I went to my gallery, as I do most mornings. But something was wrong.
What was wrong?
You see, I've looked at treason almost every day for over 30 years, but the painting that was hanging there, that was not treason.
So what did you do?
Well, I called the police. They sent Detective Barron to my estate, and I told her everything I knew.
Besides Detective Barron, did you speak to anyone else about the theft?
Actually, yes. I did call Evan.
Why?
Well, after all the times we discussed treason, I thought she would want to know what happened to it.
And how did Ms. Shem respond?
She said something along the lines of, "Oh no, that's terrible. I can assure you, I would never do anything like that." It was quite odd.
Objection, Your Honor, non-responsive as to the portion of the testimony quite odd.
No, I'll overrule that in the context of this case. I think that's a conclusion that he could come to under those circumstances.
Thank you, Your Honor. Professor, why was Ms. Shem's response odd?
Well, because I hadn't accused her of anything in the first place.
Thank you, Professor McCullough. Nothing further at this time, Your Honor.
Defense cross-examination?
Yes, Your Honor. Dr. McCullough, you own paintings in your gallery worth millions of dollars, correct?
Yes, I do. I even own a Goya.
All right, but treason was not one of your paintings that was worth $1 million, correct?
Well, it wasn't worth a lot monetarily wise, but it meant a lot to me.
It was not worth a lot monetarily, right? Excuse me. It was not worth a lot of money, correct?
Yes.
Now, turning your attention to the morning of July 5th, the morning after your 4th of July party, you entered your gallery on this morning, correct?
Yes, I did, like most mornings.
And you looked at treason?
Yes.
Now, you claim that the treason on the wall elicited a different emotional response than usual, is that correct?
It did, and not only that, but the brushstrokes were more controlled than before.
Objection, Your Honor. Creation material facts. On the first sighting of treason that morning, this witness did not notice any differences in brushstrokes.
Perhaps any help with the page?
Yes, Your Honor. Inviting court and counsel's attention to page 32, line 5, and continued on 6. Would you like me to read it aloud, Your Honor?
Let me just take a look at it. That's page 32, line 5 on to 6. Line
Yes.
5 and 6, right?
Starting with some.
Mm-hmm. Anything you'd like to respond to? It does seem to.
Your Honor, this was when Marty McCulloch entered her gallery the second time that day. This was before the phone call. This is not the point that I was referring to in my question.
Your Honor, may I respond?
Yes.
I don't believe Professor McCullough ever specified a time at which she observed these controlled brushstrokes. Furthermore, defense counsel never brought up a specific time period on that morning.
Well, let me say this. It's going to come in because it's in the factual statement. It's just a question of the timing. So I don't see where it's going to be. It would take me a while to read through the whole statement again and get the time context. I don't want to do that now, so I'll allow it. I see no prejudice to it.
Now, you received a phone call in that morning as well, correct?
Yes, I did.
This phone call is from an art dealer asking about treason, correct?
Yes, and offered to sell. It was really odd because I would never part with treason.
The phone call was about treason, yes?
Yes, it was.
And now after this phone call, you walked back into your gallery after that first sighting, correct?
Yes, I did.
And you looked at treason for a second time that day, correct?
Yes.
And only this time did you notice differences in the painting, correct?
Well, I knew something was off the moment I saw treason.
But it was only a feeling that first time, correct?
It was the second time I had a longer period of time to look at treason, and that's when I came to my realization.
You only noticed a difference in brushstrokes the second time you looked at treason that day, correct?
Yes, I guess you could say that's when I had the chance to notice it.
It was only that second time, correct?
Yes, that's what I said.
And on that same day, July 5th, you went over a guest list, your guest list, with Detective Barron, is that correct?
Yes, I did, when she came over to my estate.
And you pointed out my client Evan Shen's name on that list, didn't you?
Well, she was the only one that had access, so I thought it'd be prudent to let her know.
You gave Detective Barron Evan Shen's name, correct?
Yes, along with the rest of the guest list, though.
But you specifically pointed out Evan Shen to the detective, correct?
Yes.
Now, a few days later, you were called down to the police department to identify a painting, correct?
Yes, on July 8th.
And you only identified that painting as your own after you had been aware that that painting had been found in Evan Shen's apartment, correct?
No, I don't believe so. They told me to come down to the apartment to see a painting they had found. And after I ID'd it, they told me it was from Evan Shem's apartment.
You were called down to the police department to look at a painting, correct?
Yes, I was.
And you had been told that this painting was from Evan Shem's apartment, correct?
No, I think they told me they had found a painting involved with the case, and I went down to check it out.
And they told you where it was from before you ID'd it as your own, correct?
No, I don't believe so.
Objection on creation of material facts.
Once again, we better pause here and take a look at the statement.
Your Honor, looking at page 32, lines 25 through 26, on July 8th, Detective Barron had me stop by the police station to look at a painting taken from Evan Shem's apartment.
It doesn't specifically say they told that. That's where they got it, but it doesn't really say that. It's kind of an ambiguous area. So your objection is probably well taken. You did object, didn't you?
No, Your Honor, it was defense counsel's objection.
Oh, that's right, yes. Your objection is well taken. Thank you.
Now, you never saw Evan Shem steal treason, correct?
No, it was a party after all. I was mingling with the guests.
You never saw anyone steal treason, correct?
Well, no. I trusted that Evan would take care of and watch the gallery.
That wasn't my question. You never saw you never saw anyone at all steal treason, correct?
No, I was having fun at my 4th of July party.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Professor McCullough, why was it only the second time you looked at treason on July 5th that you were able to tell some differences?
Well, when I first walked into my gallery, I stopped and looked at treason, but then I received the phone call, so I had to leave. After I finished up with the phone call, I went back to the gallery, and that's when I had the chance to look at treason a little longer.
And how did you know that it wasn't the real treason on the wall?
Well, I've had treason for over half of my life. I know it like the back of my hand. I could tell something was off.
Thank you, Professor McCullough. Nothing further, Your Honor. May Professor McCullough be excused?
Yes. Thank you. You are excused.
People call Charlie Gibbons to the stand?
Calling Charlie Gibbons to the stand. Please follow me. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
Please be seated. Please state your first and last name, spelling your last.
My name is Charlie Gibbons. Gibbons.
Thank you.
Good afternoon, Miss Gibbons.
Good afternoon.
Do you know the defendant, Evan Shem?
Yes.
How do you know her?
Well, Evan and I met back in 3rd grade. I think it was Miss Allen's class. Anyway, we became best friends, really inseparable. Long story short, we kind of went our separate ways in high school, though.
Objection on your narrative.
I don't think at this point. It could be shortly, but overruled at this point.
Thank you, Your Honor.
Please continue, Ms. Gibbons.
Well, during high school, we went our separate ways, and then after high school, we got back in touch and became roommates for a while.
Well, as Miss Shen's friend, are you aware that she's an art student?
Yes, absolutely.
Did she ever paint?
All the time.
What did Miss Shen paint?
Well, she especially liked to paint recreations of famous pieces. They were really amazing to look at.
Miss Gibbons, do you know the painting called Treason?
I've heard a lot about it, yes.
From who did you hear about this?
Oh, Evan was always talking about treason, slipping it into every conversation.
Miss Gibbons, have you seen treason?
I did once, yes.
Did you know what treason looked like before you saw it once?
No, the only time I saw it was at Professor McCullough's party. Evan was really excited to show it to me, and when I saw it, I was a little taken aback. It wasn't what I was expecting.
Have you ever been to a party at Professor Marty McCullough's mansion before this year?
No, I wouldn't have been invited without Evan.
Now, earlier you mentioned that Evan Shem talked about treason a lot. Did you ever overhear Evan talk about treason with anyone else?
Yes, there was actually one phone call I did hear.
What did Miss Shem say on this phone call?
Well, she asked about selling treason and was using this sort of phony accent.
Did Miss Shem do anything else unusual?
Yes, actually, it was kind of weird. She was referring to treason as her own painting, and towards the end of the phone call, she mentioned something about $100,000 and seemed really excited about it.
Thank you, Miss Gibbons. Nothing further at this time, Your Honor.
Cross-examination?
Yes, Your Honor, but before I begin, the defense requests a time check.
Yes.
Defense has 2 minutes, 58 seconds, and prosecution has 4 minutes and 10 seconds remaining.
Thank you.
You recognize Evan Shem's ability to recreate famous works of art, correct?
Yes, she's really amazing.
And prior to July 4th, you overheard a phone call in which the words treason and $100,000 were used, correct?
Yes.
And also prior to July 4th, soon prior, you still possessed a key to Evan Shem's apartment, is that right?
I did. I still was storing a few things there.
So you had access to the apartment?
Yes, I did.
Now turn your attention to July 4th, Marty McCullough's 4th of July party. You saw treason on this day, is that correct?
Yes, it was the first time I saw it, and it was a little ugly. I was kind of surprised.
Now the size of treason, it's quite small. It's 11 inches by 14 inches, correct?
I think it was something like that. I didn't measure it.
And on the night of the party, you were wearing a large coat, is that correct?
Yes, I thought that would be in style. I'd never been to one of these fancy parties before.
But it was a large coat, yes?
Yes.
Now your coat was longer than 11 inches, correct?
I don't recall exactly how long my coat was.
But it's safe to say that it was longer than 14 inches, correct?
I'm not sure.
But that's a reasonable assumption to make, correct?
Objection, Your Honor. This is a creation of a material fact. As nowhere in Miss Gibbons' statement does she say what size her trench coat is.
I think it's appropriate cross-examination because it is a trench coat and that has a typical meaning to most people.
Yes, Your Honor. However, opposing counsel's question is requiring Miss Gibbons to say something that's not in her statement.
I don't think so. I don't believe so. I think it's a logical inference from the description of trench coat, which does appear in the statement. So overruled.
So I'm going to ask that question again. Your coat was longer than 14 inches, correct?
I'm just not sure how long it was. I don't measure my coat.
It was a trench coat, yes?
Yes.
Thank you. No further questions.
Any redirect?
No redirect, Your Honor. May Miss Gibbons be excused?
Yes, thank you.
The people call Bernie Worcester to the stand.
Calling Bernie Worcester to the stand. Please follow me. Please raise your right hand. Please solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition.
Yes, of course.
Please be seated. Please state your first and last name, spelling your last.
My name is Bernice Worcester, and I spell that W-O-R-C-E-S-T-E-R.
Thank you.
afternoon, Miss Worcester.
Good afternoon.
What do you do for a living?
I am the lead art curator at MT's Fine Art Auction House, and sometimes I authenticate art for the police department.
What's art authentication?
Simply put, art authentication is the method of determining whether a painting is real or fake.
And what are your qualifications for this position?
I received my master's in art history from Notre Dame in 1989, and since then I've been traveling all over authenticating art. I have become one of the leading experts on art authenticity, as I have been called in to authenticate paintings worth millions of dollars.
Miss Worcester, are you familiar with the painting Treason?
Yes, I am.
Tell us a little bit about that painting.
Treason is an abstract painting created by the artist Fletcher Yazoo. Now, since it was created in the 1970s, and due to all the political turmoil at this time, Yazoo's frustration is evident in his brushstrokes. For such a brilliant piece of work, Treason is actually relatively small, only 11 by 14 inches, and until recently was kept in a small wooden frame.
Could Treason have been easily removed from that frame?
Upon my examination of the frame, I found nothing to suggest that Treason was kept in place with any sort of adhesive or tacks or such, and therefore it could have been removed very easily using no tools at all.
And are there any known photographs of Treason?
No, there are not.
How much is Treason worth?
Around $100,000.
Did you have any other dealings with Treason besides appraising it?
Yes, in this case I was called in to authenticate Treason as well as a copy.
And what method did you use in your analysis?
Connoisseurship.
What's that?
Connoisseurship is the method of examining the style of the artist and then seeing if that style is evident in the painting.
Did Yazoo have a particular style?
Yes, of course, all artists do. Yazoo was known for his harsh and vigorous style.
Your Honor, permission for Miss Worcester to step down and approach the exhibit?
Yes.
Miss Worcester, please explain your findings to the court using those two exhibits.
Of course. My first comparison was in the thickness of the paint, in the arrow shape in the center of the painting, the right-hand side of the painting, and the bone-shaped streak in the bottom right-hand corner of the painting. Now in Exhibit A, the paint is harshly and vigorously applied, consistent with Yazoo's style. However, in Exhibit B, the paint is much too thickly applied to be the work of Yazoo. My second area of comparison was in the pink streak in the middle of Exhibit A and the pink dot in the middle of Exhibit B. Now in Exhibit A, the pink streak is unintentional, a completely accidental work of Yazoo. However, in Exhibit B, this pink dot was carefully added on by the copyist, trying to match it to the pink streak in Exhibit A.
Miss Worcester, after conducting your analysis on those two paintings, what was your final conclusion?
This is treason. This is a copy.
Thank you, Miss Worcester.
And when you refer to this, you mean Exhibit A is treason?
Yes,
and B
I'm
is-
sorry, Your Honor. Exhibit A is treason. Exhibit B is a copy.
Thank you, Miss Worcester. Nothing further at this time, Your Honor. May Miss Worcester resume her seat?
Yes. Mhm. And cross-examination?
Yes, Your Honor. Miss Worcester, in early July, you were contacted to perform an examination on two paintings, correct?
Yes, I was.
One found at the residence of Marty McCullough,
Yes,
and the other found at the residence of Evan Shannon.
that's correct.
Now I'd like to talk about your examination in specific. Could you please approach the exhibits?
Of course.
Now the paintings you examined were 11 by 14 inches, correct?
They were, yes.
And the paintings that you just testified to in direct are much larger than that, isn't that true?
Yes, they are.
But from the time that you were contacted by the police, and the time that you reported your findings, you used no forms of magnification on these paintings, isn't that true?
I did not, no.
Now, Miss Worcester, you may be seated.
And I'm sorry, I actually pronounce it Worcester.
Now, from the time that you were contacted by the police to the time that you reported your findings, you also conducted no research on treason by Fletcher Yazoo. Isn't that true?
That's correct, yes.
In fact, you relied on a simple visual examination, correct?
Partially, that's correct.
Now, Ms. Worcester, you and Ms. Sardania, the other expert that examined these paintings, each used the same points in the paintings, correct?
Yes, we do.
And you came to directly conflicting conclusions about each of those points.
That's not exactly correct.
Your determinations of the authenticity differ, correct?
Yes, however, Miss Sardania and I actually agree on many things.
That wasn't my question. Your determinations of the authenticities of the paintings differ.
Yes, they do.
So there are two interpretations of each of these paintings.
Yes.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Ms. Worcester, defense counsel just asked you if there were two interpretations of the authenticity of these paintings. Are there two correct interpretations of the authenticity?
Objection, Your Honor. Speculation.
Did you want to address that?
Yes, Your Honor. Ms. Worcester is an expert in the field of art authentication. Therefore, it's not speculation.
Any rebuttal on that?
Your Honor, although Ms. Worcester may be able to testify to her findings, she cannot for sure say that hers is the absolute correct one.
Well, I think it's inappropriate. She can testify to exactly what she feels her expertise merits, and she's done that. So to characterize it further, I think, is argumentative, really. So I'll sustain the objection.
Thank you, Your Honor.
You're welcome.
Ms. Worcester, in your professional opinion, which of those two paintings is authentic?
Exhibit A is the real treason. Exhibit B is a copy.
Thank you, Ms. Worcester. Nothing further, Your Honor. May she be excused?
Yes, thank you. Excused.
And at this time, the people rest.
Very good. Then the the defense, are you ready to present your witnesses?
Yes, Your Honor. The defense would like to call Jamie Sardania to the stand.
Calling Jamie Sardania to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated.
Thank you.
Please state your first and last name, spelling your last.
Jamie Sardania, Sardegna.
Thank you.
Ms. Sardania, are you currently employed?
I am, yes.
How?
I work as an art authenticator for Experts Incorporated, based in New York City.
How are you qualified for this position?
I have a master's degree in art history from New York University, specializing in abstract art, and I have worked in the field for the past 15 years.
Are you familiar with the artist Fletcher Yazoo?
I am, yes.
How?
He is one of the artists I became very familiar with during my time in grad school.
And are you familiar with Yazoo's painting Treason?
I am.
How?
I, fortunately enough, had the opportunity to view this piece 3 years back at Marty McCullough's 4th of July party.
Ms. Sardania, how are you involved in today's case?
I was asked to authenticate 2 pieces resembling treason.
Where were these pieces found?
One was found in Marty McCullough's mansion, and one was found in Evanshem's apartment.
Ms. Sardania, did you conduct any research in preparation for your analysis?
Yes, an extensive amount.
What did you research?
I researched the artist in question, his style, other pieces by him.
Did you use any particular analytical techniques in your analysis?
Yes, I did employ the use of digital imaging software to help reach my conclusion.
What did this software allow you to see?
Digital imaging software allows you to see the brushwork in such close detail that you can determine the angle of the painter's hand as they painted and even the pressure that was exerted.
Your Honor, may the witness approach the exhibits?
Yes.
Ms. Sardania, are you familiar with Exhibit A?
I am, yes.
How?
It is a picture of the painting that was found at Evanshem's apartment.
And are you familiar with Exhibit B?
Yes, I am.
How?
It is a picture of the painting that was found at Marty McCullough's mansion.
What, if any, points on these 2 paintings led you to your conclusion?
I would say there were 4 factors that led to my conclusion. First was the overall style of the pieces. Second, the arrow-shaped mark in each piece. Third, the bone-shaped streak in each region. And fourth, the pinkish region.
Beginning with overall style, what exactly was the style of Fletcher Yazoo?
Fletcher Yazoo was notably aggressive in his work. He would unevenly apply paint in vigorous motion. He would add little spontaneous details as the mood struck him. Rough bristle marks were a mark of his work.
And did you find any one of these two paintings to be more consistent with his style?
I found Exhibit B to more closely resemble Yasu's style.
Next, what was the relevance of the two arrowhead shapes in your conclusion?
In Exhibit B, the arrowhead shapes were thicker than they were in Exhibit A, a fact I found very consistent with Fletcher Yasu's style of unevenly applying paint in vigorous motion.
Next, how did the pink streak in each painting impact your conclusion?
While in Exhibit B, the pink dot here is inconclusive as to whether it is a remnant of red paint and white or a spontaneous add-on, both are very much in line with Yasu's style. He was actually known to add little details as the mood so struck him.
And finally, Ms. Sardegna, how did the bone-shaped streak impact your conclusion?
While in Exhibit B, I found the bristle mark on the bone-shaped streak to be sufficiently rough enough to be authentic Yasu. In Exhibit A, they appear to be carefully added on, as if by a copyist trying to be too Yasu-like.
Ms. Sardegna, what was your final conclusion as to the authenticity of the two paintings?
I determined that the painting in Exhibit A, found in Evanstrom's apartment, was a very well-created replica, while the painting found in Exhibit B, Martin Polk's mansion, is the original Treason by Fletcher Yasu.
Thank you, Ms. Sardegna. You may be seated.
Thank you.
No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Sardegna.
Good afternoon.
Now, I wrote down something that you said on direct examination, just because I wanted to make sure that I got it completely correct. You said that brush bristle marks were a hallmark of Yasu's work, right?
One of them, yes.
And you agree that the bone-shaped streak in Exhibit A has more bristle marks?
That is factually correct.
Now, I'd also like to turn your attention to Exhibit B, because you also mentioned the pink oval.
I did.
Now, Ms. Sardegna, that pink oval could have been an add-on by a copyist, right?
Or by Fletcher Yasu.
That's a yes, it could have been an add-on by a copyist?
The determination I made is that it was done by Fletcher Yasu.
But Ms. Sardegna, you agree that it could have been an add-on by a copyist?
What could have been remains inconsequential, as I have determined that Exhibit B is the authentic Treason.
Is that a yes?
Could you clarify what you mean by is that a yes?
Ms. Sardegna, you made a report to the police in this case, right?
That is correct.
Now, I'd like to invite court and counsel's attention to page 42, line 35. Do you have it, Your Honor?
I do.
It is certainly possible that it is an afterthought and an add-on of pink paint by a copyist. Now, Ms. Sardegna, I'd like to talk to you a little bit about methods that you use to form your conclusions. You mentioned on direct that you used digital analysis.
That is correct.
But you agree that a computer alone cannot authenticate art.
Which is why I did not use a computer to authenticate my art.
And you also used Morellian analysis.
That is correct.
As did Ms. Worcester.
As far as I'm aware, yes.
And you agree that Morellian analysis is more important than digital analysis, right?
The determination was made through Morellian analysis. Digital imaging software merely allowed me to take a closer look in order to augment my use of Morellian analysis.
So that's a yes?
Could you repeat the question in that case?
Morellian analysis is the most important part of your analysis?
That is correct.
Now I'd like to talk to you about your familiarity with the painting Treason. On direct, you mentioned you'd seen it before.
Yes, I have.
You've seen it once.
That is correct.
3 years ago?
That is correct.
Briefly.
That is correct.
At a party?
That is correct.
So you didn't examine it in any sort of professional capacity?
I never claimed to.
Thank you, Ms. Sardegna. Nothing further, Your Honor.
All right, and any redirect?
Briefly, Your Honor.
Yes.
Ms. Sardegna, did a computer conduct your analysis of these two paintings?
The one that conducted the analysis was me.
And what did you determine?
I determined that the painting found at Evan Shem's apartment was a very well created replica, while the painting found at Marty McCall's mansion, hanging in her gallery, is the authentic treason painted by Fletcher Yazoo.
Thank you, Ms. Sardegna. Thank you, Your Honor. No further questions. May
Thank
this
you.
witness be excused?
Yes, thank you. You're
Thank
excused.
you.
The defense calls Evan Shem, Your Honor.
Thank you.
Calling Evan Shem for this hearing.
And at this time, the defense would also request a time check.
Defense has 9 minutes, 42 seconds, and prosecution has 7 minutes, 18 seconds.
Thank you.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your first and last name, spelling your last.
Evan Shem. S-H-E-M.
Thank you.
Good afternoon, Ms. Shem.
Good afternoon.
How old are you?
I'm 24 years old.
Are you currently attending school?
Yes, I'm fortunate to attend Hamilton University.
What do you study?
Well, I'm earning my Master's of Fine Arts with an emphasis in the painting styles and techniques of mid-20th century abstract expressionists.
Ms. Shem, do you create your own art?
Yes, I do.
What types?
Well, I create my own paintings as well as I do recreate paintings that I'm studying in school.
Ms. Shem, have you ever shown your paintings to anyone?
Yes, I've showed my paintings to Charlie Gibbons and my former professor, Marty McCullough.
What's your relationship like with your former professor, Nicole?
Well, I used to be in Professor McCullough's art history class, and I also used to work for Professor McCullough as an intern.
What did you do with this internship?
I took care of Professor McCullough's paintings, made phone calls, and did basically anything Professor McCullough asked me to do.
Now, Ms. Shem, are you familiar with Treason by Fletcher Yazoo?
Yes, I spent a tremendous amount of time with Treason in Professor McCullough's gallery.
Did you ever recreate this painting?
Yes, back in March.
Ms. Shem, turning your attention to Exhibit A, do you recognize this?
Yes, I do.
What is it?
This is my recreation of Treason.
Is it a fair and accurate depiction of your recreation?
No, it's not. It's bigger than my recreation of Treason.
Now, Ms. Shem, did you ever do any research on the painting?
Yes, I did.
How?
Well, I contacted MT's Fine Art Auction House, and I also looked into collectors of Fletcher Yazoo's work.
Ms. Shem, turning your attention to Exhibit D, do you recognize this?
Yes, I do.
What is it?
This is a note I made into the research of Fletcher Yazoo art collectors.
Is it a fair and accurate depiction of that note?
Well, it's bigger than I remember it, but it's definitely my handwriting.
Now, Ms. Shem, there's 4 names on this note. Could you explain why they're there?
Oh, yes. These are all collectors of Fletcher Yazoo's work. I was looking in to see if Treason was worth any more than any other Yazoo works.
Now, Ms. Shem, you also mentioned that you had called MT's Fine Art Auction House. Why did you do that?
Well, I wanted to get an appraisal on the painting Treason.
Ms. Shem, during this phone call, did you disguise your voice?
No.
Did you imply that the painting was your own?
No, of course not.
Did you imply that you were looking to sell the painting?
No, I made it very clear. My only intention was to find the value of Treason.
And Ms. Shem, why were you doing all of this research?
I just wanted to impress Professor McCullough. For the last few months, I've been on a mission to prove to her that Treason has more than just an emotional value.
Now, Ms. Shem, I'd like to talk about the night of July 4th. What, if anything, happened?
Well, I attended and worked at Professor McCullough's annual 4th of July soiree.
You mentioned that you were working. What were you doing?
I served as a docent in Professor McCullough's gallery.
And what did that job entail?
I escorted guests around the gallery, answered any questions, and most importantly, I was supposed to lock the gallery at 9 o'clock.
Now, Ms. Shem, you said that you were supposed to lock the gallery. Did you?
No, I was just so caught up in the rush of the evening that I completely forgot. But 10 to 15 minutes later, I made sure to go back to the gallery, lock the door, and go back to the fireworks show.
Ms. Shem, did anyone attend this party with you?
Yes, my former roommate, Charlie Gibbons.
Did Charlie Gibbons ever enter the McCullough gallery?
Yes.
Did you ever show Charlie Gibbons where Treason was within that gallery?
Yes, I showed Charlie the painting Treason.
Ms. Shem, did Charlie Gibbons have access to your home on that evening?
Yes, Charlie still had a key to my apartment, as she had just been living in my apartment a few days before.
And Ms. Shem, where was your recreation of that evening?
In my apartment.
And where did you normally keep your recreation?
In my apartment.
Ms. Shem, did you leave the party with Charlie Gibbons?
No, I did not.
Why?
Well, I was just feeling so tired after I had forgotten to lock the gallery that I searched around for Charlie, but I just couldn't find him, so I left.
Thank you, Ms. Shem. Thank you, Your Honor. No further questions at this time.
Cross-examination?
Yes, Your Honor.
So sorry.
Thanks.
Good afternoon, Ms. Shem.
Good afternoon.
Now, I noticed something you said on direct examination. You just said that you went back to the fireworks show after you locked the gallery, right? That's not what you say in your report, is it?
Oh, I don't know.
Now, inviting court and counsel's attention to the most recent errata, page 36, line 7. Shortly after the fireworks display, I tried to find Charlie. I had agreed to let Charlie crash on my couch for the night, but I wasn't going to spend all night looking. It had been a long evening, and I was ready to go.
Your Honor, if I may.
Yes.
This line says shortly after the fireworks display, saying that Ms. Shem did in fact see the display. It would imply that she went back and then after that could not find Charlie Gibbons.
I think the question is all right, but the witness basically has answered that she's not sure, so I don't know what to do with it.
Your Honor, may I respond as to the inference?
Yes.
Your Honor, in this case, material inferences are not admissible as pursuant to Rule 3.5.
Well, tell me one more time what you're asking her.
Your Honor, I said that Ms. Shem never reported to go back out to the fireworks show. Inferring from the errata that she went back to the fireworks show is a material inference and is not admissible.
Your Honor, Ms. Shem seeing the fireworks show is not material to this case, and as it says in the errata, shortly after the fireworks show.
I think it's all right. So let me just make sure who's objecting here. And
she was trying to perjure my witness.
That would be a conclusion, but I think it's proper. In other words, she can go ahead and answer. I don't think this is outside the scope of the statement here. If she's able to, but I got the impression she didn't have that information.
Yes, Your Honor. Now, Ms. Shem, all you say in your statement is that you went home after the fireworks show, right?
Yes, after...
You never said you went to the fireworks show, right?
No, I didn't.
Objection, Your Honor, relevance.
It's something you can both argue to me at the end, how that should be interpreted. I'll overrule it.
Thank you, Your Honor.
Now, you also mentioned on direct examination that treason has great emotional value, right?
To Professor McCullough, yes.
Now, I'd like to talk to you about your financial situation. You're in debt, aren't you?
Yes, but I view it more as an investment into my future artwork.
So currently, you're on your way to amassing $125,000 in debt, right?
Yes, that's true.
And at the moment, you have no way to pay that debt off, right?
No, but I'm planning on finding a job.
Now, I'd like to talk to you about treason. As you mentioned on direct examination, you called MT's Fine Art Auction House, right?
Yes, I did.
A day or two before the July 4th party?
Yes.
And you found out that treason was worth $100,000, right?
Yes, I couldn't wait to tell Professor McCullough.
But you never told Professor McCullough that you'd found this out, right?
No, I just never got the chance.
You never told Professor McCullough that you had done research on treason in the first place, right?
No, I didn't. See, I was waiting to surprise Professor McCullough with my findings.
I would like to talk to you about the July 4th party. You were the docent that evening, right?
Yes.
So you had full access to the gallery?
Yes.
And that's where treason was displayed?
Yes.
You were supposed to lock the gallery at 9 p.m., right?
Yes, I was.
And as you said on direct examination, that didn't exactly happen, did it?
Not at 9.
Exactly. You went back around 10 or 15 minutes later?
Yes.
And that was when everyone was outside watching the fireworks show, right?
Objection, Your Honor, speculation. Ms. Shem does not know exactly where everyone was.
Your Honor, may I be heard?
Yes.
As Professor McCullough's docent that evening, Ms. Shem knew that the fireworks show started at 9 p.m. as Professor McCullough had instructed her to lock the gallery at 9 p.m.
Yes, I think she can testify overruled.
Thank you, Your Honor.
So when you went back to the gallery around 10 or 15 minutes after 9, that was when everyone was supposed to be outside watching the fireworks show, right?
Well, everyone was supposed to be outside, yes.
So you know reason to believe that anyone was inside, right?
Right.
I'd like to talk to you about your relationship with Professor McCullough. You were her intern, right?
Yes, and former student.
And she said that after one semester, this internship might become a paid position, right?
Yes, but that promise never materialized.
Exactly, and you weren't too thrilled about that, were you?
No, I wasn't exactly thrilled, but I started to plan on finding a new job.
In fact, you asked Professor McCullough about it one day, didn't you?
Yes.
And she told you to be patient?
Yes.
And that marked a turning point in your relationship with Professor McCullough, didn't it?
Yes, but only professionally.
I'd like to talk to you about your own artwork. You said you like to make recreations of famous paintings, right?
Yes, I do.
You often show these to Professor McCullough?
Yes.
You made a copy of Treason, didn't you?
Yes, a recreation of treason.
Now, you never mentioned showing this copy of Treason to Miss Gibbons, do you?
Can you repeat the question, please?
Nowhere in your statement do you say that you showed Miss Gibbons your copy of Treason, right?
I showed Miss Gibbons many of my recreations, but not necessarily treason.
Exactly. Miss Shep, you never said that you showed Miss Gibbons your copy of Treason, right?
Correct.
You never showed Professor McCullough your copy of Treason either, did you?
No, I didn't. You see, Professor McCullough loved treason so much, I thought she'd be overcritical of my work.
Now, Miss Shem, you never even told Professor McCullough that you'd made a copy of Treason. Is that correct?
No, I did not tell Professor McCullough.
Thank you. Nothing further.
Any redirect?
Yes, Your Honor. Ms. Shem, when you went back to lock the gallery between 9:10 and 9:15, can you for 100% say that no one else was in the house?
I can't say if no one was else in the house.
And Ms. Shem, has Charlie Gibbons ever seen your recreations before?
Yes.
And has Charlie Gibbons ever been alone in your house before?
Yes.
And Ms. Shem, where do you keep your recreations?
In my apartment.
Thank you, Your Honor. No further questions at this time.
The next, first you're excused. Thank you.
The defense like to call Sydney Ogden to the stand.
Calling Sydney Ogden to the stand.
But before I begin, the defense like to request a time check.
Defense has 5 minutes, 2 seconds remaining, and prosecution has 2 minutes, 55 seconds remaining.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your first and last name, spelling your last.
Sydney Ogden, O-G-D-E-N.
Thank you.
Mr. Ogden, what is your occupation?
I'm fortunate enough to serve as a librarian at the Hamiltonia Public Library, as well as at ballet on the side.
Do you know Evan Shem?
Yes, I do. I've known Evan since forever, but we became best friends in sophomore year of high school.
What is your opinion on Evan Shem's integrity?
Evan is reliable and honest. I can always trust her with anything.
Where were you on the night of July 4th?
I was serving as a valet at Marty McCullough's mansion.
Did you recognize any of the guests at the party?
Yes, I recognized Evan Shem, my friend, and Charlie Gibbons, an acquaintance.
Who was Charlie Gibbons?
Charlie Gibbons, I knew Charlie Gibbons from high school. He used to be friends with Evan, but they drifted apart in sophomore year.
Were you ever able to go inside the mansion at any time during the night?
Yes, I was able to get a look around when I went to look for the bathroom.
And what if anything occurred at 9 p.m. that night?
Mr. McCullough put on a fabulous fireworks show.
Your Honor, may the witness approach the exhibit?
Yes.
Now, directing your attention to Exhibit C, do you recognize this exhibit?
Yes, I do. This is a diagram of Marty McCullough's mansion.
Is this diagram accurate?
Yes, it is. I would say so.
Objection, Your Honor, lack of personal knowledge.
You want to address that?
Yes, this witness was able to go inside the first floor of the mansion during the night.
May I be heard, Your Honor?
Yes.
Mr. Ogden was at the McCullough mansion for one night as a valet. He would have no opportunity to thoroughly examine the first floor of the mansion and be able to testify that this layout is fair and accurate.
I think it's well taken. I'd sustain it, but you can ask a question as to the areas that he actually had an opportunity to see that, if this diagram reflects accurately what he remembers of the...
Move to strike what answer?
Strike that answer, but she can go ahead with the next one.
Thank you. Where were you standing during the fireworks show?
I was standing right here at the front of the covered porch.
Were you able to look inside the mansion at this time?
Yes, I was able to see through the front doors in the mansion right here.
And what were you able to see when you looked inside?
I was able to see the living room and the hallway and most of the first floor right there.
Were you able to see the fireworks show?
Yes, I was. I was able to see the fireworks show out on the lake here through the giant glass window at the back of the mansion.
Now, were you able to see where Charlie Gibbons was during the fireworks show?
Yeah, a few minutes before the fireworks show, Charlie was at the back of the patio where all the other guests were. But then, several minutes into the fireworks show, around 9 to 9:15, I saw Charlie exiting the hallway right here.
Now, what was Charlie Gibbons wearing at this time?
Charlie was wearing a tan trench coat.
Objection, Your Honor, relevance.
Your Honor, many witnesses, including Charlie Gibbons himself, have testified that Charlie Gibbons was wearing a trench coat that night. This just further clarifies that it was Charlie Gibbons that this witness saw that night.
I think it's relevant, overruled.
Thank you. Now, looking at the exhibit, what is the only room at the other end of that hallway?
The gallery right here.
Thank you. You may be seated. No further questions at this time, Your Honor.
And then cross-examination?
Yes, Your Honor. Permission to approach Exhibit C?
Yes.
Good afternoon, Mr. Ogden.
Good afternoon.
I'd like to ask you about the party on July 4th. You testified that you saw Miss Gibbons walking around the mansion?
Yes, I did.
Now, you testified that you saw her leaving the hallway that leads to the gallery?
Yes, I did.
But you never saw her exiting the gallery itself, did you?
No, I didn't.
You thought that she might have gotten lost looking for the bathroom.
I wasn't really sure what she was doing. I
Objection,
assumed...
Your Honor. Counsel is asking the witness to speculate.
It's true, but he's answering in a way that reflects what he actually saw, so I think it's all right, overruled.
Thank you, Your Honor.
You thought that Miss Gibbons might have gotten lost looking for the bathroom.
I wasn't sure what she was doing. I assumed that she might be looking for the bathroom.
Just like you had earlier that evening.
Yes.
And the bathroom is right next to the hallway, isn't it?
Yes, a little bit before the hallway.
Now, you also testified that you saw Miss Gibbons wearing a tan trench coat.
Yes, I did.
But wearing a trench coat doesn't make someone a thief, does it?
Objection, Your Honor. Counsel is asking this witness to speculate.
Yeah. Sustained, yes.
Thank you, Your Honor.
But you couldn't tell if Miss Gibbons was hiding anything?
No, I couldn't.
Thank you, Mr. Ogden. Nothing further, Your Honor.
Any redirect exam?
No redirect, Your Honor. May this witness be excused?
Yes, thank you. You're excused.
And at this time, the defense like to move Exhibit C into evidence.
C. That was not already received? If it wasn't, everybody agree it should come in?
No objections, Your Honor.
All right, received.
Thank you, Your Honor.
The defense would now like to call Mr. T.M. Little to the stand.
Calling T.M. Little to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform the facts and rules of the mock trial competition?
I do.
Please be seated. Please state your first and last name, spelling your last.
My name is T.M. Little, L-I-T-T-L-E.
Mr. Little, are you currently employed?
Yes, I am.
How?
I'm currently working as an art dealer and have been doing this for over 30 years.
Are you familiar with Marty McCullough?
Yes, I am.
How so?
We were dear friends for 20 years and recent business partners.
Are you familiar with Evan Shem?
Yes, I am.
How?
I met her many times at Marty's mansion when I went for social and business affairs.
During these instances, did you note anything about her behavior?
Yes, she was hardworking and very polite.
Mr. Little, did you attend any events on July 4th?
Yes, I did.
What events did you attend?
I attended Marty McCullough's annual 4th of July soiree.
At this soiree, did you see Evan Shem?
Yes, I did. I saw her 3 times.
What were those 3 times?
I saw her when I arrived at the party, since we arrived around the same time, then for a second time being courteous to all the guests, and for a last time during the fireworks show. I ran into her in the foyer.
Before the fireworks show, was Miss Shem acting any differently than you'd ever seen her before?
No, not at all.
Mr. Little, did her behavior seem to change at all during the fireworks show?
No, not at all.
Mr. Little, are you familiar with Charlie Gibbons?
Yes, I am.
How?
I met him for the first time at this most recent soiree.
And at the soiree, did you notice anything unusual about Charlie Gibbons' behavior?
Yes, he was sweating, shaking, and wouldn't look me in the eye when we shook hands.
Thank you, Mr. Little. No further questions at this time.
In cross-examination?
Yes, Your Honor. Good afternoon, Mr. Little.
Good afternoon.
Now, on direct, you mentioned that you saw Miss Shem 3 times on the night of July 4th, right?
Yes, that is true.
And on the night of July 4th, you saw Miss Shem holding a backpack.
Yes, she said it contained art supplies.
Objection, Your Honor, non-responsive.
Yes, sustained.
Move to strike the portion of the answer after yes.
Granted.
So you saw her holding a backpack?
Yes, that is true.
And that same night, the 3rd time you saw her leaving the gallery hallway.
Yes, that is true.
And that was during the fireworks show?
Yes, that is true.
You didn't see anyone else inside besides you and Miss Shen, right?
That is true, yes.
So it's safe to assume that everyone else was outside.
Objection, Your Honor. Counsel is asking this witness to speculate as to the location of 200 guests.
Sustained, yes.
Thank you. Move to strike if any.
If there was an answer, it's stricken.
Thank you.
Mr. Little, when Miss Shem was exiting the gallery hallway, you didn't see anything in her hands, right?
No, I did not.
But you made no mention of seeing her holding a backpack on her back, right?
That is also true, yes.
Thank you, Mr. Little. Nothing further, Your Honor.
Anything further?
Briefly, Your Honor. Mr. Little, did Miss Shem explain why she had a backpack?
Yes.
Objection, Your Honor. This calls for hearsay.
Would you like to address that?
Your Honor, this...
It certainly seems like hearsay, unless you've got some other exception. I would have to sustain the objection.
Your Honor, this is not being offered for the truth of the matter, but instead for the effect on the listener.
I don't think so. I'll sustain the objection.
Move to strike if any answer given.
Yes.
Thank you, Your Honor.
You're welcome.
Mr. Little, did Miss Shem seem nervous at the party?
No, she did not.
Thank you. No further questions. May this witness be excused?
Yes, and thank you. You're excused. Is there any further defense evidence?
No, Your Honor. At this time, the defense rests.
All right, now we come to the final argument, and people, if they're ready, are you ready to present your final argument?
Yes, Your Honor. May it please the
Yes.
court? As Ms. Sakota told the court in opening, at the beginning of today's case, there were 3 people in this courtroom who knew which of those 2 paintings was the real one. And now we all know. Exhibit A, the painting found in the defendant's apartment, is the authentic treason. Your Honor, Why was that painting in the defendant's apartment? Because the defendant put it there. Now, Your Honor, today the defense has tried to raise reasonable doubt in this case. They tried to tell you that Charlie Gibbons might have stolen the painting. But, Your Honor, the evidence simply does not support that for two very clear reasons. First, Your Honor, it's indisputable today that the crime required planning. Someone had to bring a fake of treason to the party on July 4th, and someone had to anticipate that she would have the opportunity to switch out the two when no one else was around. Your Honor, Miss Gibbons had no way of anticipating that Miss Shem would leave the gallery unlocked. In fact, Miss Gibbons could not have known that she would have the access to pull off this crime. Furthermore, Your Honor, today both the defendant and Miss Gibbons told you that the first time Miss Gibbons had ever seen treason was on the night of July 4th. And in fact, she was surprised at how it looked. There aren't any known photographs of treason, and the defendant never showed her copy of treason to Miss Gibbons. So how could Miss Gibbons have known which painting to steal? How could she have known which fake to bring to the party? Your Honor, the defense's explanation of those pieces of evidence simply is not reasonable. Your Honor, in order to prove the defendant guilty of grand larceny in today's case, the people must prove, 1, that treason was worth more than $950, 2, that the defendant took treason without Professor McCullough's consent, and 3, that the defendant took treason with no intention of returning. And Your Honor, only one of those elements is disputed today, because we heard unequivocal evidence that treason is worth $100,000. We know that Professor McCullough never consented to the theft of her painting. And if the defendant did in fact take treason, then it's also undeniable that she never intended to return it. So what today's case comes down to is one simple question. Did the defendant take treason? And Your Honor, today the people have proven beyond a reasonable doubt through the defendant's own words and actions that she did. Let's take a look at the defendant's words. Today, you heard testimony of 2 incriminating phone calls. First, on July 2nd, just 2 days before the theft, you heard that the defendant offered to sell treason to an art auctioneer. On that phone call, she disguised her voice. She claimed that treason was hers, and she was elated to find out that the painting was worth $100,000. Your Honor, $100,000 was just enough to cover her debt. Second, on July 5th, the day after the theft, Professor Marty McCullough called the defendant and told her that treason had been stolen. And what was the defendant's first response to the news? "Oh no, Professor McCullough, I can assure you, I would never do anything like that." But Your Honor, the defendant hadn't even been accused of anything yet. So why was she denying involvement before an accusation had even been made? But the defendant's words aren't the only thing that implicate her in today's case, Your Honor. The defendant's actions do so as well. Because today you heard that the defendant, and the defendant alone, is an expert forger. And she admitted today to making an expert forgery of treason. What's more, Your Honor, today you learned that the defendant had a note in her storage cabinet. And this note contained 4 names, each of collectors of people who would buy Jesus' paintings. Your Honor, this wasn't so that she could find out the value of treason. She was calling people who she specifically knew would purchase a painting by Jesus. It's a list of her buyers, Your Honor. What's more, today you learned that the defendant, and only the defendant, had access to the gallery on the night of July 4th. And after she ushered all the guests outside, it gave her the perfect opportunity to switch the fake in her backpack with the real treason. But perhaps most damning for the defense's case is the fact of the testimony of Bernice Worcester. Because she got up on stand and she told you that this is the real treason and that this is a fake. Well, what's more, Professor Marty McCullough, the person who's been looking at this painting for 30 years, looked at this painting on the morning of July 5th and said, that's not it. This isn't treason. Your Honor, in light of all the evidence in today's case, the defendant's words, the defendant's actions, and the fact that the real treason was found in the defendant's apartment just 3 days after the theft, there's no doubt the defendant stole treason. We ask that you find her guilty as charged.
The defense argument?
Yes, Your Honor. The defense would also like to request a time check before the finish.
Defense has 5 minutes, 54 seconds for their closing.
Thank you. Earlier in today's case, you heard that art and beauty are subjective. They fall victim to the perceptions of their beholders. And with that in mind, Your Honor, consider the people's case. In terms of art, it's nothing but an elaborate array of brushstrokes that the people are struggling to find meaning in. It's subjective. It has multiple reasonable interpretations. But the truth, Your Honor, the truth should not be subjective. But in a court of law where the truth is not always known, it is the people's job to prove their perception of the truth beyond a reasonable doubt. Today they have not done that, though. Because every piece of evidence, every fact, every point that they have asserted has multiple reasonable interpretations. The people have not met their burden of proof because they have not proven that a crime was committed. Your Honor, they have perceived my client as someone she is not. Now I'd like to point out 3 glaring examples of reasonable doubt in the people's case. A biased investigation, the question of each painting's authenticity, and lastly, an alternate assessment. Now let's take those one by one, beginning with the people's investigation. Well, the people's investigation, based upon Marty McCullough's word, was biased towards my client from its beginnings. Because you see, Your Honor, on July 5th, it was Marty McCullough that perceived wrong. McCullough walked into her gallery. She looked at treason on the wall. Then she received a phone call. And that phone call is about the painting she'd just been looking at. Now, Your Honor, Ms. McCullough shied away from the fact that prior to that phone call, she failed to notice any objective differences in that painting. She only noticed them after. Because, Your Honor, when McCullough walked into her gallery that morning, no crime had been committed. She looked for an explanation for a crime that she herself imagined. Now, Your Honor, I'd like to talk about the lead detective on that case, Reese Barron. Well, Reese Barron told us that in most cases of art theft, there's nothing but a blank, empty space on the wall. Detective Reese Barron found no blank, empty space. In fact, Detective Reese Barron found no fingerprints, no break-in points, no evidence pointing to my client, and no evidence pointing to anyone. Now you see, Your Honor, the prosecution would like you to believe that this lack of evidence pointed to an inside job. But I ask you, does it point to an inside job, or rather the fact that a crime never even occurred? Now second, to further cement the fact that treason never left Marty McCullough's home, the defense called art expert Jamie Sardegna. Now, Ms. Sardegna and the prosecution's expert, Ms. Worcester, each used connoisseurship, and they each used their years of experience But Your Honor, then things start to differ. Because you see, unlike Ms. Sardania, the prosecution's expert, Ms. Worcester, did not use special digital imaging software. She does not specialize in abstract art, and she did not conduct any research on Fletcher Yazoo and/or treason. Your Honor, the prosecution cannot prove that the painting actually left McCullough's mansion. They cannot prove that my client took that painting. Now, lastly, if the court has been swayed to believe that a crime was in fact committed, there's still an alternate suspect. Your Honor, the wild card guest at the party with access to each copy of treason on the night of July 4th. Now, I don't need to tell you that that individual is Charlie Gibbons. Now, today, the defense called Sidney Ogden. And Sidney Ogden told the court that between 9 and 9:15 p.m., he saw Charlie Gibbons exiting the hallway that led to the gallery. And what was Charlie Gibbons wearing, Your Honor? Well, a large tan trench coat. And Charlie Gibbons shied away from the fact that that trench coat was longer than 14 inches and wider than 11 inches, could have easily concealed the 11 by 14 inch painting. Charlie Gibbons had also had numerous conversations with Ms. Shem about that painting, and also knew that it was worth $100,000 prior to that night. Your Honor, all of the evidence that the defense claim, or that the prosecution claims to have against Ms. Shem duly applies to Charlie Gibbons. Now, Your Honor, today the prosecution has tried to paint a picture of my client as a thief. They tried to tell you that she stole this painting from Marty McCullough. But Your Honor, they perceived her as someone she simply is not. Ms. Shem would have never committed a crime against art, a crime against an employer that she held very dear, and a crime against a painting that she loved. Your Honor, the prosecution's accusations against my client are unfounded because they are unproven. Today, you've been presented with 3 interpretations of the evidence, but only 2 of them are reasonable. Either someone else stole the painting, Charlie Gibbons, or, all the more likely, the painting never left Marty McCullough's home. Now, Your Honor, each of these reasonable interpretations point to reasonable doubt in the people's case. And they each point to one verdict. Not guilty. Thank you.
Yes, and people wish to have a rebuttal argument?
Yes, Your Honor. Art is subjective. The law is not. And the defense's doubts are not reasonable. Your Honor, the defense brought up the point that the painting may never have even been stolen. And that's the crucial fact that this case revolves around. But Your Honor, today you saw Ms. Sardania on the stand. You saw her impeached, you saw her combated, and you heard her say that brush bristles were the hallmark of Yazoo's work, and there were more brush bristles in Exhibit A, the painting found in the defendant's apartment. What's more, Your Honor, Charlie Gibbons could not have stolen the painting. She had neither the access nor the knowledge, and she had no way of predicting that she would have that chance. Your Honor, the doubts brought up by defense counsel are not reasonable. And as a result, we ask for a verdict of guilty of murder.
I can fill in the blank.
Yes, Your Honor.
Your Honor, it's unreasonable to base a case upon an unquantifiable feeling that Marty McCullough had. It's unreasonable to base a case off of an investigation that yielded no evidence. It's unreasonable to assume that someone $125,000 in debt would steal a painting worth only $100,000 when there were ones worth millions in the gallery. It's unreasonable to base a case off of an investigation that was focused on one individual. And as we've seen today, there's another equally as likely. And Your Honor, I don't need to tell you that Ms. Sardania's testimony is just as reasonable as Ms. Worcester's if not more. Today, the prosecution has tried to paint over the reasonable doubt in their case, but it's showing through. Please find a verdict of not guilty. Thank you.
All right, very difficult case, and there is a considerable amount of evidence that certainly points the finger at the defendant in the case. Nevertheless, most of that evidence is circumstantial evidence, which is good evidence, but if there's reasonable interpretations of it that can point towards guilt or innocence, the court's obligated to take that interpretation that points towards innocence. The fact of the expert testimony concerning the authenticity of the work does raise a reasonable doubt. Reasonable doubt is not no doubt at all, I'm aware of that. But on the other hand, in this case, I have a real question as to whether a crime was committed, so that I cannot find the defendant guilty. So I will find her not guilty. And of course, you know my finding has nothing to do with anything in the case. It's just a way to conclude it here today. So let me just say that you did a really professional job. Every year, it's the same really professional performances. One thing, just in a sort of tactical comment, your professionalism is shown by the way you not only argue and so on, but the way you object and not object. It's kind of a hallmark of beginners that they object at everything, and usually loudly too. Your objections were restrained and they were well taken. Even if I didn't sustain every one of them, they were certainly very arguable objections that had some merit to them. And not only were they articulated well, but they were responded to well by whichever side was responding. And then that's really the real hallmark of a professional in court. I know that most of you will not be lawyers, probably. You probably don't want to do that. You want to go some other way. Maybe you've done your fill of it in this class, but some of you may well be. I have to mention, I went yesterday afternoon, I went to a memorial for a local attorney who passed away recently. Really fine attorney, knew him for many years. And all of you, I'm sure, have probably read To Kill a Mockingbird, Atticus Finch, and those of you who haven't really should. And this gentleman certainly personified Atticus Finch. He was that kind of a person that was not only a very fine attorney, but he was well regarded by even his opponents, the people who appeared in opposition to him. And so the hallmark of a really fine attorney, in my opinion, is somebody who not necessarily argues a lot. You hear parents and relatives saying, "Oh, so-and-so, my boy or girl, likes to argue at everything. Oh, he should be a lawyer." That's not the hallmark of a fine lawyer, necessarily. Arguing is fine, but the hallmark is really the person who can be ethical, considerate of all the people involved, that it be the clients, the court, the opposition, and so on, witnesses. And this person had that. And his name was Charles Warner. There was another individual with the same first name, Charles, that died recently, Charles Towns. And he was one of the inventors of the laser, got a Nobel Prize, a brilliant physicist. And he, when they had his obituary and the comments in the press about him, they all talked about what a brilliant physicist he was. But someone who knew him well over the years said, that's not really what hit you first. What hit you first was what a really nice person he was. And that's the kind of thing you really want to strive for, whether you go into the profession of law or whether you do something else. So congratulations, you did a beautiful job. You were very courteous to each other and very professional. Thank you.
Thank you.
And this year, second place goes to Pacific Grove High School.